So we're here with Elise Martin from HHG Legal Group. Elise, welcome. Can you just give us a bit of background about yourself and the firm that you work for?
Yeah, sure. So I am a senior associate at HHG Legal Group, and I specialise in estate planning and deceased estate administration, which means I help my clients plan their wills, enduring powers of attorney, things like that, and also help families work through what needs to be done when a person dies. The firm generally does provide a number of services through employment law, commercial litigation, and also family law being the core areas.
Yep, cool. Well, thanks for joining us. So can you just, let us know what broadly happens if you die without a will?
Okay. If you don't have a will in Western Australia, the Administration Act applies, and this is a piece of legislation which sets out who's entitled to your estate if you pass away and you haven't got a will. Depending on your personal circumstances and the family members that you leave behind will determine who gets your estate when you die if you don't have a will. One thing to note is the Administration Act is currently going through some changes in Parliament which are being looked at, and so there may be significant changes to that piece of legislation coming up soon.
So I guess passing away without a will, does that make the process for, the remaining beneficiaries or family members a difficult process without a will?
Yeah, it can make it more complicated. Depending on who you've got in your family, it might mean rather than all of your assets going to your spouse, for example, they get split between not only your spouse but also any children, which I've seen have fairly significant financial impact on a surviving spouse when they don't have access to all of those funds which they could have had if a will had been drawn up.
Okay. And can you just elaborate what a enduring power of attorney and enduring power of guardianship, does and what that is?
Yeah, certainly. So there's two different types of documentation in Western Australia which can be prepared to assist managing your affairs if you lose capacity, but before you die. So the first is the enduring power of attorney, which you mentioned, and that covers a person's financial matters. It allows people to perhaps deal with land transactions or contact government agencies or utility authorities on your behalf as well as banks.
Yep.
The enduring power of guardianship is a decision-making document where you specify who is going to make decisions for you regarding any health or lifestyle matters which may need to be considered if you lose capacity to make those decisions for yourself. So treatment options, care in the instance of aged care facilities or things like that.
Okay. What is the importance of a will, and what are some of the key documents that may be, covered off within that will?
So within the will, you can nominate who your executor is. Now that's the person who's going to manage your estate and your affairs after you pass away, which is a really important person, and it's important to give proper consideration to who is a trustworthy person who would be able to take on that role for you, but also somebody who within themselves has the capacity to do that important role for you. You can also name who you specifically want your beneficiaries to be, which may be different to who would benefit from your estate if you died without a will and under the Administration Act. And also you can appoint who you'd want to be guardians for your children. Now this is a wish, but it's often one of the best places to include this type of information because it's not often a conversation that people may have, or there might be some uncertainty in relation to who is the best person to care for children in the event of a death.
Can the executor be the same person as the beneficiary?
Yeah, definitely. There's no requirement that a beneficiary can't be an executor, or that being an executor would exclude somebody being a beneficiary.
Okay. And can you have multiple executors, or a replacement one? So you might put an executor in place, and then when you pass away, that person's already passed away?
Yeah, most definitely. We generally do recommend that people either consider having joint executors if that's appropriate for their situation, or alternatively that they have at least one person as a backup, for example, in the event that the person that they want as their first preference is unavailable or has already passed away, like you mentioned.
Okay. And having joint executors, do they both need to sign off on where that money goes or is paid out to?
That's correct. So if people are given a grant of probate, being joint executors, then they must act together. But just being named in a will as an executor doesn't mean that you're required to be the executor. So if it's not appropriate for you in that situation, you can always step back.